concludes our 10:30 docket.
Thank you, Mr. Shima. We'll now call 126-626 State of Kansas versus Johnson. You may begin when ready.
Good morning, Your Honors. Corinne Gunning, Assistant Appellate Defender, appearing on behalf of Darren Johnson. I would request 3 minutes for rebuttal.
3 minutes is granted.
Okay. To begin, for the reasons stated in this brief, I would ask this court to vacate Mr. Johnson's felony murder conviction and remand for resentencing to second-degree murder as the primary offense and misdemeanor fleeing or attempting to elude. In the alternative, Mr. Johnson requests a remand for a new trial. As I see it, the primary problem in this case stems from the charging decision of the state. It charged Mr. Johnson for a car crash with 2 counts of murder, not in the alternative, and rested the charge of felony murder on a felony that never occurred. There is no question that Darren, in this case, did not stop his car when Officer Scott turned on his lights and sirens, that he ran a red light and turned on to 21st Street here in Topeka off of Indiana Street. But then Officer Scott affirmatively stopped that pursuit. When Darren drove his car at a high rate of speed on 21st Street, ultimately resulting in the crash, he was not being pursued by police officers at that time. He was also not fleeing from committing a felony at that time. At most, the failure to stop on Indiana Street was a misdemeanor fleeing and lewd. At no point did Darren ever commit all elements of felony fleeing and eluding at the same time. That is the question that I have put before this court, is whether or not that is required. And I think the state, I think that the case law demonstrates that if you're going to be convicted of a felony offense, if you're going to be convicted of any offense, all of the elements have to occur together. Generally speaking, unless this court has said otherwise or the legislature.
Let me get back to the question of the pursuit. This kind of presents an interesting question. When you watch the two the cams that are on the vehicles, it almost appears that there's very little separation between Officer Scott deactivation of his lights and Officer's good pursuit of the vehicle. Is there any kind of, is there a buffer? Is there some sort of, does it have to be continuous? What?
I would say that
as soon as you deactivate your lights, the pursuit is over. Is that what that is? Is that how we look at that?
If I'm looking at the elements of the offense, yes, because it's activate lights and sirens pursuing police vehicle. From my perspective, I maintain that Officer Good never pursued. There was never a pursuit by Officer Good. If I'm remembering correctly who he was, had started the process of potentially beginning a pursuit.
Well, he observed, it's pretty clear he observed this car flying through a red light.
Correct.
And turned and immediately started pursuit, activated his lights and began a pursuit. And then you can see the accident occur. Yeah. Not quite simultaneously, but almost simultaneously with that action.
And if we look at what Officer Good's statements are, he even testified he hadn't really had the opportunity to start a pursuit before the crash happened. And I understand the difficulty of, I mean, everything in this case happened very quickly.
Within 30 seconds, a minute to 30
a minute, yes. And so everything happened very quickly, but we still have to have all of those elements occur together. And I don't believe that we had a police pursuit at the time that Darren was arguably driving recklessly.
What in the statutory language requires them to be simultaneous in time? All I see is a knowing failure to stop once given an audible or visual signal and involvement in a motor vehicle accident. It doesn't say they have to happen at the same time.
As I put in my brief, I won't know the case off the top of my head. I apologize for that. The appellate courts have largely held that the elements do have to occur together, that you can't have a case unless we have some sort of continuing offense. It's audible or visual signal of a pursuing police vehicle. And when we don't have a pursuing police vehicle who has an audible or visual signal to stop, I don't think that we have a fleeing and elude, because we don't, at that point in time, how is the person supposed to, I mean, I understand.
I mean, your argument suggests that as soon as the officer disengages the chase, that the driver of the fleeing vehicle doesn't have any obligation to stop. Is that right?
That's my position, yes. And
Is it right under the law? I mean, I understand that's your position, but under the statutory language, what would suggest that?
Because you're not fleeing from a pursuing police vehicle if they're not giving you a signal that you have to stop. And I mean, I think just like from my perspective, a logical perspective, if a police car is behind me and they don't have their lights and sirens on and they're not giving me but they stay behind me for an extended period of time, if they then tell me that I fled from them because they were pursuing me, because they were following me, how was I supposed to know that I was supposed to stop? In this case, I understand the facts are different because we do have some bad conduct that does occur. But I'm not sure that it's fleeing and eluding amounting to a felony. Certainly, I mean, I have no problem in this case. I had no argument in my brief that this was reckless conduct, which is second-degree murder. And for most of the time, a car crash that occurs like this is a reckless second-degree murder. I think there were two distinct periods of time here when Darren was on Indiana Street and then when he was on 21st Street. And on those two separate streets, not all of the elements of felony, flee, and elude come together.
Why doesn't reckless driving come together with his actions in the initial pursuit? When Officer Scott turns around and activates his lights, observes the vehicle, speed, and you look at the video, it's a very narrow road with no curbs, tree lined, residential area, and runs a red light. That's pretty clear. You can see that when he's pursuing. Why aren't all those factors fit with reckless driving?
I'll have two answers.
And other factors. Just
I'll have two answers to that. I'll be honest, yesterday, as I was preparing for this argument, I watched the video from Officer Scott's dash cam ad nauseum. And there's a 5-second period, 4 to 5 second period from when he turns his lights on to when Darren turns on to 21st Street. And in that period, he's down the street, you see his brake lights go on and he goes through the red light. Both of those two things, I mean, I suppose you could say that he is speeding. I think that's a factual question for the jury on whether or not he's speeding on Indiana Street. Officer Scott said he was, and then he went through a red light. Those are two moving violations. And so my argument would be that if we say that those two independent moving violations where nobody is around and where there's arguably no danger in that area for harm to another person, I think we don't have reckless conduct. We have 2 of 5 moving violations in a pursuit, which is another way to get to felony, flee, and elude. And the alternative, my answer is, then that would be a fact question for the jury, whether or not that is reckless conduct. And in this case, the jury maybe could have made that decision. I don't see the state in its case arguing that. I know that this court has not necessarily held the state to what arguments it presents at closing. The state largely rested on the speed at the time of the crash and the crash itself as the reckless conduct. But if we're going to leave that to a jury, they should have a definition of what reckless conduct is, which has a specific legal definition that they didn't have. And some people might just in their mind say, well, I wouldn't run a red light. I think it's reckless to run red lights. Was it wanton or willful conduct? that can lead to injury to other people or damage. And they didn't get that instruction, and so I don't think that they had the proper lens in which to view that conduct and whether or not it was reckless. If we're going to look at that right there as supporting the reckless.
Couldn't they have looked to the other instructions that defined reckless?
I would say no, because reckless driving itself has a specific definition in the statutes that does not match the state of mind instruction necessarily.
How's it different? Because the statutory definition of reckless driving is willful or wanton disregard for the safety or persons of another. How's that different than a conscious disregard of a substantial and justifiable risk that's a gross deviation from the standard of care?
I think it specifies, wanton or willful is, I would say that's, I know conscious, but wanton or willful is a more specific choice.
It seems like a broader choice because the reckless definition, the general definition almost seems to cover wanton, but not necessarily willful. But the statutory definition of reckless driving is willful or wanton.
I think that's more specific than sure, yes, it's more specific than just disregard, I think. And then we're talking about a specific result rather than a general result that might occur. And this, the appellate courts have said that when we don't give that instruction, when we're charging felony, flee, or elude, the jury doesn't have the right frame for which they're looking at it. I know in some of those cases, we don't have another crime that has the reckless element in it, so that question hasn't really necessarily been resolved.
But those are separate issues, right? One's the sufficiency question,
yes.
And we look at the evidence in the light most favorable to the state to resolve that issue.
Yes.
But so your sort of second argument and response was, well, then we turn to the instructional error issue.
Yes.
Right. Okay.
Yes. So it is my position that this court can find that did not amount to reckless conduct, and that no jury would find that it is reckless conduct. And then in the alternative, if there's a question there, it's a question for the jury to resolve, and they didn't have all the instructions that they needed to resolve that question. I do see that my time is up. So unless there are further questions right now, I'll reserve the remainder of my argument for rebuttal.
I see no questions. Thank you.
Good morning again. May it please the court. The state appears by Deputy District Attorney Jody Lippin. I will continue on with the discussion today of the first issue. And our position is that the state presented sufficient evidence here of the felony fleeing or attempting to elude a police officer. As Justice Stiegel was pointing out, nothing in the statutory language or plain language of the statute supports the defendant's argument.
Well, I'll flip it around now.
Okay.
Which is, I guess, a warning on not taking a question to mean that's my position necessarily. I think there is an answer to that question from our Irvin case just recently, in which we basically said, look, the elements do have to happen simultaneously, and a jury cannot, I'll just reading, the jury must limit its consideration to the driving during the pursuit and may not look at his actions after the pursuit ended. How do you get around that or distinguish it?
And I was looking to see if I could find the specific facts in Irvin, and I didn't do a deep dive, but I don't know what the testimony was about the pursuit. If the officer said, I know in the opinion, I think it said they were told to end the pursuit and they ended it. So here, I don't think we have the same evidence of the end of the pursuit.
Well, how do you deal with Officer Scott's testimony? His testimony when he said, no, I was driving the normal speed limit without pursuing the vehicle after he turned off his lights and sirens. How do you get around that?
the way that I think that the state is viewing that testimony is to link pursuing with lights and sirens. It's a departmental policy. I think there was some testimony that we have to end the pursuit, meaning we have to turn off our lights and sirens. And that's not the same as what the statute says in pursuing. Pursuing isn't connected to lights and sirens. So I think we're talking about a departmental policy of we have to end the pursuit, meaning turn off our lights and sirens. That doesn't mean that he is not, as pursuing is defined, following in order to overtake or capture. He said he was still turned, I think it was turned left onto 21st Street. He was still going in the direction of the defendant where he went, although he did lose sight of him. But because he lost a visual, he was complying with the department policy to turn off his lights and sirens.
Your argument is that pursue, the legal definition of pursue is broader than lights and sirens.
Yes.
And that was the precise issue, although in a different context, that we considered in the Irvin case. There's just some language in there that really cuts against your argument, but I wanted to explore whether perhaps Irvin is a case of potentially unintended consequences.
Well,
Another
Urban,
line
I
of,
would just, if I can interrupt it with that, in Urban, I believe the facts were that the police officers turned around. They went into an entryway and actually turned. So your distinction between lights and sirens and pursuing was really not at issue in Irvin,
right.
factually. So
But there's some
go ahead.
dicta, which I was getting to in Irvin. For example, I'll read another line. The reckless acts considered under the fleeing and attempting to elude count must have occurred while police car lights and sirens were activated. I mean, if that's right, it's the facts here strike me as it would be difficult for the state to make out its case. But then obviously the follow-up is that right?
Sure. And I guess I would just say this court still didn't define what pursuit was.
Right. The context here was whether or not the jury needed to be given an instruction defining pursuit, and the Irvin court, we said, no, you don't need to define pursuit. But just I'm concerned about, I wanted to hear your responses to some of this language that was used in that decision.
And I agree that, and knowing the facts, Your Honor, now, if they did turn around and really end the pursuit, and that was the evidence that was shown, I think that's different than the evidence that we have here. He never stopped pursuing. He turned off his.
For you to prevail, do you need us to disapprove some of the language that we just published in our?
I hadn't thought about that. I don't know. Maybe you could just do a factual difference. But I do think that linking the lights and sirens to pursuit is not supported by the statute.
But you would agree or concede that in this case, the accident occurred after the lights and sirens were terminated or turned off?
Yes.
Okay.
I think, yes, based on the videos. And I think it's, the reason I hesitate on that is because I think Officer Good's testimony was, I was in the process of turning on my lights. And I mean, this all happened as Your Honor
It's bang,
said.
bang, bang. And your argument is from the bang, bang, bang nature of it, it's silly to just look at lights and sirens because we should look at the pursuit globally and conclude the pursuit was ongoing.
Correct.
Okay.
Correct. And I think it's a dangerous precedent to say lights and sirens off, pursuits ended. I mean, that's not the way that plays out. And that's very dangerous. So I think it's different here. I think it's not their argument's not supported by the statute.
Let me ask a question to follow up on Justice Rosen's. If we go to reckless driving, so it's my understanding that Officer Scott testified that when the lights were going and the sirens were going, okay, so we have this active pursuit, that Johnson accelerated and continued to accelerate as he traveled above the speed limit for a few blocks before running a red light to turn left onto Indiana, and that the body cam footage, which was played for the jury, showed that it was dark outside during the pursuit and that the street that he turned on was lined with trees, suggesting that, maybe oncoming traffic wouldn't have been or limited or whatever. So if that is, so could we say, okay, the question presented is whether that is sufficient to prove or to establish reckless driving under, I understand that the definition wasn't given or whatever, and then when you do that, and then you look at the felony murder statute, which says whether, and I had it down, what, that, if, the felony is, the murder is either before or during or after, the underlying felony, then do we get there that way, or is that not a good way to go?
Let me see if I'm understanding your Honor's question. Is it just, are we talking about what facts do we have to support that there was actually reckless driving during the time that the lights and sirens were on? If the
Yeah.
court wants to go that way with pursuit equaling lights and sirens on. I think that the testimony from the officer was that when he initially saw the Kia, he turned around, turned on his lights and sirens, and he saw the Kia punch their acceleration. So an excessive amount of speed on a residential area, and then blew through that red light. Granted, it's 4 or 5 a.m., so maybe there are not that many cars out, but that doesn't negate the fact that that was really reckless behavior to go almost, well, when he wrecks 30 seconds later, a minute later, he's going nearly twice this, 80 miles per hour or more.
Yeah.
At 100 miles, he reaches 100 miles eventually.
Right.
So I don't think that those two things in combination are not reckless. I don't think that there's any way that we can argue that it's not. Punching the acceleration, clearly having seen the officer, lights and sirens on, boom, go, blow through a red light. And then if we watch the Axon video from Officer Scott, seconds later, there's a car that comes through that intersection at 21st and Indiana. Had he been there and blown through that red light right then, there could have been the accident then. So I think that does establish recklessness. If we're going to go with, you have to have reckless driving while engaged in a pursuit, and pursuit equals lights and sirens, that's that. If not, I think Your Honor maybe is talking about my alternative argument of, if we don't find that happened engaged in reckless driving or a motor vehicle accident during the pursuit, it's certainly the flight from a completed flee and elude like this court had in Urban. So I think under the felony murder, you can get there that way as well. Because it happened all within the res justi of the case. And then Your Honor, I want to make one more point. I think that I think got written down. Going back to Urban and the definition of pursuit, I think there was actually language in that opinion also that talked about, if that definition would have been given, it would have been actually misleading. And that pursuit definition talked about, you don't terminate the pursuit. I can't remember exactly what the instruction did, but I think that also bolsters our case to say that if that definition of pursuit would have been given and this court found it was like a misleading or not proper, that's kind of what we have here. So I wanted to get that out before I forgot that. And unless are there any further questions?
Clarify your position on the lack of a definition of reckless in the reckless driving instruction. Are you suggesting that it was legally appropriate because all of the elements of the offense were in the jury instruction, and then you look to see if the definition, or was it, what's your position on that? I think the defendant's questioning the legal appropriateness of it without the instruction, without the definition instruction.
Sure, Your Honor. I think that we recognize that the PIC instruction, whatever PIC instruction that is, 66-110, does say under circumstances where reckless driving is used, it should be defined pursuant to the statute. It wasn't here. Just because that's incomplete doesn't make the instructions as a whole or that instruction legally incorrect. And I think that's the distinction that we're making here. And a couple of important concepts that this court looks at, we look at the instructions as a whole to figure out whether they've misled the jury or whether they were legally incorrect. And there was 2 other instances here where recklessness was defined, granted not in that PIC instruction, but the absence of that doesn't mean that recklessness wasn't defined as a whole to the jury and given to the jury. I can't remember the other 2 instructions, the second degree murder, and I think the lesser.
Doesn't that kind of go to a harmless analysis rather than whether it was legally appropriate?
Well, we're in a clearly erroneous.
Well, it was defined somewhere else so they could reach the conclusion.
I guess I think about it as, can he meet his burden to show that it was clearly erroneous? And I think that helps to show that he cannot, because there was these given, because we're not really in a harmlessness because this wasn't requested here. But
I meant clearly erroneous.
Yes, I think that goes to show that he can't meet his burden because it was. And again, there's also language from this court saying not every specific term needs to be defined. And even if this wasn't in the PIC, I think we could argue that this is a known term that the jury could understand and didn't need the specific definition of recklessness. And then if the court has no further questions, I guess I can quickly hit on the prosecutorial error claims. There are kind of two categories here of prosecutorial error: misstatements of law and inflaming the passions of the jury. And the state here would argue that the prosecutor did not commit error in any of these comments or statements. He did not misstate the law and didn't inflame the passions of the jury when talking about holding the defendant accountable or going after the bad guys. That was a statement on the evidence. And then their kind of isolation of their last argument as to the inflaming of the jury, where the prosecutor said it's based on the evidence because the evidence supports it. That's why you should convict of first degree and second degree murder. That's unquestionably a proper statement by the prosecutor. And just for all the reasons set out in the brief, we would argue that there was no prosecutorial error here, and harmless error alternatively, if this court does find any. But other than that, I don't think I have any further presentation, Your Honor.
Any other questions? Okay, thank you.
Thank you.
I'd like to start back with the question of, was there a pursuit? As I've heard the state argue here today, is that the pursuit never ended. And in my view, their brief says differently. They conceded that the pursuit had stopped. On pages 14 and 15, they acknowledge Officer Scott's statements that the pursuit had stopped. So if we go with what I'm hearing some of the discussion here today, to say, well, he said the pursuit stopped, but he was still following. I'm wondering what a jury is to do if they hear this testimony that says, I was not pursuing, the pursuit stopped, I was not in pursuit, I had not started my pursuit. And then the state argues in their closing argument, of course he had to stop his pursuit. We have these rules. Of course there wasn't time to start a pursuit. He's driving too fast for a pursuit to begin. And that's what the jury has in making its decision, where an element is a pursuing police vehicle. And then we come here to the Kansas Supreme Court, and this court says, well, it doesn't really matter what he said. It matters, like, well, are we continuing this pursuit? Is he still following him? When does it stop? I don't know what a jury is supposed to do in those situations when they have testimony, when they have argument that says there was no pursuit.
Well, in Irvin, just to go back to that most recent case, which seems to be pretty important to this case, there is some language in there that I think you heard me question your opposing counsel that arguably supports your point about lights and sirens.
Correct.
But the ultimate holding might cut against you when we said pursuit does not need a definition with a jury. So why isn't this just a jury question? They got the elements and they could decide, had the pursuit ended or not? And under these facts, why was it unreasonable for them to conclude that the pursuit had not ended when they consider the totality of the circumstances?
Again, I kind of have a two-part answer there. First, I think I love being able to talk about the facts of Irvin and not just jail credit with Irvin. But like with Irvin, one, the issue is not the same. There wasn't a challenge to the felony fleeing and eluding. It was really to the res gestae part of it. But in this case, if we have the pursuit, if we have two people saying they didn't actually have a pursuit, at one point there was a pursuit. And I think that the jury, I have no argument that Officer Scott wasn't at some point pursuing that vehicle, and that he didn't stop. And those are all the elements of misdemeanor, flee, and elude. So I think that we do have the misdemeanor present. We weren't given a misdemeanor instruction. We weren't given that as something for the jury to consider. And the state, I think all of this comes together, which goes to my cumulative argument, but all of this comes together. The state made these arguments saying, well, we had a pursuit here. It doesn't matter that it wasn't happening at the time that we have the reckless driving. And the argument was that the reckless driving was the 70 or 80 miles an hour on 21st Street. The argument was that the crash are the things that are elevating the offense. The argument of the state was not when he accelerated on Indiana Street, that was reckless. But the argument there is we had a pursuit and we had the crash. And because those two things did happen, it doesn't matter if they're happening together or not. And that is the basis of my prosecutorial error. So I think this court still can find that there was not evidence, but I also think that the jury was not given the right frame of mind in which to look at the evidence based on the argument of the state.
How can we ignore the res gesti under that argument? Because was he not alluding at that point? And we're talking seconds, right?
Yes.
We are talking seconds. And so why is he not eluding the pursuit?
The argument in order to get to the felony fleeing and elude and the felony murder is that pursuit did not amount to felony.
I'm sorry,
was not felony fleeing and elude. That
So-
pursuit and the higher speed. I mean, I hope that you all watched the videos and have watched the videos. The higher speed on that road and the turning was not reckless driving per the definition. So it was only a misdemeanor. And if you're fleeing from a misdemeanor, that's not felony murder.
So it all comes back to that question.
Yes, is whether or not there was ever a felony flee or elude. And my argument is that there was not, and therefore there cannot be a felony murder for fleeing from a felony flee or elude, which again was not the question in Irvin. I think there was no question in Irvin that he was committing felony flee or elude. I do have questions about whether or not he was, the time of the turning off and things like that, because it was having watched the video in that case, it was immediate after the lights and sirens went off and on a very busy street. But that also, it just wasn't the question in Irvin as well.
Well, and the state is actually the one who in Irvin told the jury, once the lights are off, pursuit's ended. I mean, they define pursuit that way, and that's why that discussion occurs there.
I would say,
and contrary to what the state's arguing here.
And I would say in this case that, I would look at Officer Scott's testimony as telling the jury that lights and sirens off means the pursuit is stopped. That's what I took from his testimony.
And well, I don't think we need to go, but we did use a broader definition than that in Irvin. We used the Black's Law Dictionary, which is the act of chasing to overtake or apprehend, which could be without lights or sirens, arguably.
Right, and my perspective is because the lights and sirens is part of the, and the legislature doesn't go, bullet pointed the way that the PIC instruction does, but it's a list of, a pursuing, that you've failed to stop after giving a visual or audible signal to stop for a pursuing police vehicle. And so since I see nothing there that indicates that the legislature does not intend for all those things to happen together.
Well, what if an officer is on foot and he shouts, "Stop, police"? Does he have to keep shouting "Stop, police" every 5 seconds?
I think that he should be continuing to give some sort of signal, visual or audible signal to somebody.
Do you think that's what the statute means? That this audible or visual cue has to be ongoing? Or you just get it once and then you got it?
I suppose that my first note is that we have a completely different statute for officers on foot, that this is a vehicle, pursuing police vehicle.
Okay.
So I'm not sure that we have the same conversation.
Do you think it might be different?
It might be. I obviously do not have that statute at the top of my head, but we do have a relatively recent new statute for police foot pursuits. This with the statement of a pursuing police vehicle seems to indicate that their visual audible signal is lights and sirens. I can't think of another.
But it also includes police bicycles. The statute is pursuing a police vehicle.
Yeah, a bicycle is included in that, yes. Which I think do have the ones I've seen from the Capitol Police do seem to be equipped with equipment
With some kind of light.
of lights. and maybe a siren. I've never been stopped by a police bicycle or seen her stop. So with that, if there's not any other questions, I would ask this court vacate the felony murder conviction as well as the flee and elude and remand for resentencing to second-degree murder, or in the alternative, remand for a new trial with a proper instructions on these offenses.
Thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement.